Welcome back, everybody. I am seeing you after a very long time. So, to cover up the gap that we have created, we'll try to cover the syllabus a little bit fast and little bit regular. So, in today's class, we will be discussing Order 32, which deals about the suits by or against minors or persons of unsound mind. Then, we will be going to Order 32A, which deals with suits related to family. We'll see what speciality this order has. Then we have Order 33, orders by indigent person. Indigent or indigent person? Indigent or indigent person. Okay, we'll have this. So this is the today's agenda, and we'll try to cover it as fast as possible with perspective from the prelims. We have Order 32, suits by or against minors or persons of unsound mind. Minor to sue by next friend. Order 32 Rule 1 says that if minor is suing as a plaintiff, if minor is a plaintiff, then he will sue by next friend. Every suit by minor shall be instituted in his name by a person who is in suit shall be called next friend of the minor. In this order, minor means a person who has not attained the majority within the meaning of Section 3 of Indian Majority Act, that is 18 years. This question arises that under 32, we consider the age as, so we consider the age who has not person not attained under the Section 3 mentioned Indian Majority Act 1875, where the suit relates to any of the matters relating to Clause A or Clause B of Section 2 of that Act or to any other matter. So the act which we need to look as Indian Majority Act, Section 3. Alright, that is 18 years. Where suit is instituted without next friend, plaint to be taken off the file. So where suit is not without the next friend, plaint is to be taken off the file. If you will see the reason behind why are we making the child to file a suit with the next friend, because giving him such a benefit that he won't have to come to the court regularly. If he needs any assistance, then he could get the assistance properly. So if the suit is not instituted without the next friend, plaint has to be taken off the file. If the suit is instituted by and have the minor without an next friend, defendant may apply. The defendant application will be there. The defendant may apply to have the plaint taken off the file with cost to be paid by the pleader or by the other person to whom it was presented. Now, cost will also be presented by the pleader or the person who has presented, and the defendant will have to apply for the application. Notice of such application shall be given to such person, and the court, after hearing his objections, if any, may make such order in the manner as it thinks fit. Under Order 32, Rule 2A, security to be furnished by next friend when so ordered. Where a suit has been instituted on behalf of the minor by his next friend, the court may at any stage of the suit, either of its own motion or in the application of the defendant, for reasons to be recorded, order the next friend to give security for payment of all costs incurred or likely to be incurred by the defendant. So, since it is not a criminal proceeding, it is a civil proceeding. Defendant can also apply for the application for the security for the cost to be paid, for the payment of all costs incurred by the defendant or is likely to be incurred, to give security. Alright, where suit is to be instituted by an it is indigent person. So by an indigent person, the security shall include the court fees payable to the government. The security shall include, okay, so if the person is indigent, and then the security will be including the court fees payable to the government also. And this has been added by 1976. This won't be asked. 1976 one, if you just write down, but this won't be asked. The provisions of Rule 2 of Order 35 shall, so far as may be, applied to a suit where the court makes an order under this rule directing security to be furnished. Order 35, Rule 2 provision, we need to just remember it. When we'll go to the Order 35, then we will make a connection just related to the payment of costs and security. Then that provision needs to be applied here. Third, guardian for the suit to be appointed by the court for minor defendants. So when the plaintiff is there, we have next friend, but we have guardian where we have defendants, and that guardian would be appointed by the court. So, and that is written in Rule 3. So where the defendant is minor, the court on being satisfied of the fact of his minority. So the court first will be satisfied of his minority. Then the court will appoint a proper person to be guardian for the suit for such minor. In order for the appointment of guardian for the suit may be obtained upon application in the name and on behalf of the minor or by the plaintiff. So even the plaintiff can file the application at court asking the court to appoint a guardian for the minor defendant, or on the behalf of the minor the court can also do so. An order for the appointment may be made upon the application in the name and on behalf of the minor, or so application is required, or by the no suo motu. Such application shall be supported by an affidavit verifying the fact that the proposed guardian has no interest in the matter in controversy in the suit adverse to that of the minor, and that he is fit person to be appointed. So this is the ground of appointment. This is the ground of appointment of a guardian, that in such application supported by an affidavit. So the guardian would give his affidavit verifying the fact that the guardian has no interest in the matter in the controversy in the suit, plus and he is not adverse to that of the minor, and he is in a fit person to be so appointed. Okay. Order shall be made on an application on this rule except upon notice to any guardian of the minor appointed or declared by an authority competent in this behalf. The notice will serve. The notice would not be served when the guardian is appointed by an authority competent in that behalf, or where there is no such guardian upon notice to father, or where there is no father to the mother upon notice to father and mother, where there is no father, mother, natural guardian of the minor, where there is no father, mother, natural guardian to the person whose care the minor is, after taking any objection which may be urged on behalf of the person served with notice under this rule. The court may, in any case if it thinks fit, issue notice under sub rule 4 to the minor also. To the minor also we have added separately. Okay, this was not added. This, both are one. A person appointed under sub rule 1 to be guardian for the suit for minor shall, unless his appointment is terminated by retirement, removal or death, continue as throughout the proceedings arising from the suit, including the proceedings in APA to divisional court and in proceeding in execution of degree. So only the ground for the removal is removal, death or retirement, and aside from this will also represent the minor and appeal it in divisional court proceedings in execution of degree also. Decree against minor not to be set aside unless prejudice has been caused to his interest. So decree against minor not to be set aside unless prejudice has been caused to his interests. What do you mean by this? No decree passed against a minor shall be set aside merely on the ground that the next friend or guardian for the suit of the minor had an interest in the subject matter of the suit adverse to that of the minor, but the fact that by reasons of such adverse interest in the next friend or for the prejudice is caused to the interest of the minor shall be a ground for setting aside the decree. So he said the rule 3A is saying that just because on the reason that the guardian has adverse interest in the subject matter of the minor would not provide sufficient reason to set aside a decree against minor, unless the reason is supporting that prejudice has been caused to the interest of the minor, then the decree can be set aside. Okay, against minor only, then it would be set aside. Nothing in this rule shall preclude the minor from obtaining any relief under any law by reason for the misconduct or gross negligence. So on what ground the minor can also file a claim? Misconduct or gross negligence on part of the next friend or guardian for the suit resulting in prejudice to the interest of the minor. So if the interest has been prejudiced or then on the misconduct and the gross, the minor can also file a suit, plus the decree can also be set aside. So he can do both. Who may act as next friend to be appointed guardian for the suit? Any person. So this is the qualification. This is the qualification, and can be asked. Who is appointed as next friend of the guardian? So any person who is of the sound mind, has attained majority, may act as a friend of the minor as guardian for the suit, provided that the interest of such minor is not adverse to that of the minor. Only requirement is that any person could be made person of sound mind majority, only is that he should not be adverse to that of the minor, and that he is not in the case of the next friend or defendant, or in the case of guardian of the suit a plaintiff, and he should not be a plaintiff. he is not in the case of next friend, a defendant, or in the case of guardian for the suit, a plaintiff, neonachi, not adverse. Where the minor has a guardian appointed or declared by competent authority, no person other than such guardian shall act as an extent of the minor unless the court considers for reasons to be recorded that is for the minor's welfare that another person be permitted to be act as appointed as the case may be. No person shall without his consent in writing be appointed for the guardian of the suit. So written consent is necessary. Written consent is necessary. No person shall be without his consent in writing. Where there is no person fit or willing to act as a guardian, the court may appoint any of its officer. So no one is willing or no one is fit for that minor. Then what court may do? Court may appoint any of its officer to be such guardian and may direct that the cost to be incurred by such officer in the performance of duties as guardian should be borne either by the parties or by any of the more of the parties to the suit, or out of any fund in the court in which the minor is entrusted, or out of the property of the minor, and may give directions to the repayment or allowance of such cost as justice and circumstances of the case may require. So the court may appoint any of its officers to be guardians, direct that cost to be incurred by such performance duties be borne by parties or by any of the more of the parties or any fund in the court. The court is so generous. The court said that the cost can be paid by the party or by the fund, any fund in court. If there is a special fund in court, then any fund in court which in which minor is entrusted, or out of the property, or out of any fund in court in which the minor is entrusted, out of the property of the minor as circumstance may require. Representation of minor by an external guardian for the suit. Every application of the court on behalf of the minor other than application on rule 10 we are coming on rule 10 sub rule 2 shall be made by his external guardian. So every application shall be made by this. Other than this, we'll see what is this. Every order made in suit and application before the court in which minor is anyway concerned or affected without such minor being represented by an external is as the case may be discharged. Every order made in a suit or an application which minor in a way is concerned or affected without minor being represented may be discharged with the pleader of the party at whose instance such order was obtained knew or might reasonably have known fact of such minority which caused to be imposed by such pleader. The discharge of the minor right. Receipt of next under guardian of suit or property and a decree for minor. A next under guardian of suit shall not, without the leave of the court, receive any money or other movable property on behalf of the minor, either by way of compromise. To the next friend shall not, without the leave of the court, indulge by way of compromise before a decree or order movable property on behalf of the minor, receive any money or other movable property under a decree in favor of the minor, either way of, so neither by compromise and neither by a decree or order in favor of the minor without the leave of the court, receive any money or movable property either by way of compromise and the decree where the next friend has not been appointed or declared by the competent authority to be guardian, having so appointed or declared as under disability known to the court to receive the money. Other the court shall, if it grants him leave to receive, may require such security, give such direction as will in sufficiently to protect the property from waste and ensure its proper application. Provided court may, for reasons to be recorded, dispense with such security while granting leave to the next friend to sue to receive money, other movable property under a decree or order by such next friend. Guardian is the manager of Hindu HUF, Hindu divided family, or relates to the property of the business family, or a parent of the minor. Then this case dispense with the security. Parent or HUF, decree or order relates to the property of the business, and the manager and the decree or order is the property of the business family. Agreement or compromise by next friend. No next friend or guardian shall, without the leave of the court, expressly recorded in proceeding, enter into an agreement or compromise in behalf of the minor with reference to the suit in which he acts as the next friend or guardian. An application for leave under sub-rule 1 shall be accompanied by an affidavit of the next friend or guardian in the suit as the case involves the minor driven by freedom. Benefit of the minor, opinions of them. And this is important. Every agreement or compromise without the leave of the court so recorded shall be voidable against all parties other than the minor. Voidable against all parties other than the minor. Okay. Retirement. Unless otherwise ordered by the court, a next friend shall not retire without first procuring a fit person. So it's a duty. It is the duty of the guardian, next friend. Okay, it's the next friend. Duty of the next friend to not retire unless he finds a fit person to be put in his place by giving security for the costs already covered. Application for appointment of new friend shall be supported by an affidavit showing the fitness of the persons. The 8 is retirement, 9 is removal. Is it reversed to that of the minor is so connected that the defendant whose interest is reversed as the minor is to make the unlikely that minor will be properly protected by him, or where he does not do his duty, or during the pendency the suit ceases to decide within the India abroad, or where any other sufficient cause application made by the behalf of a defendant, the court is satisfied with the sufficiency of the cause assigned, may order the next friend to be removed accordingly and make such the order cause as may be. Where the next friend is not a guardian to be appointed or declared by competent who desires to be himself appointed in the place, the court shall remove the next friend unless it considers for reasons to remove that the guardian ought not to be appointed. This is a stay of proceedings removal of next friend, where the pleader of such minor omits within a reasonable time to take steps to get a new next friend appointed. Any person interested in the minor or in the matter in issue may apply to the court for the appointment of one. Court may appoint such person as it thinks fit. Okay. The pleader omits. Any person interested in the minor or matter in issue may apply to the court for the appointment of one. On the retirement, removal, death, the next friend, minor further proceedings shall be stayed. So what will happen? Stayed until the appointment of the next friend. Retirement of guardian, so where the guardian is to retire or does not do his duty, whether the sufficient ground is made to appear, the court may permit such guardian to retire or may remove him, may make such order as a thing. The guardian for soon during the pendency, the court shall appoint a new guardian in his place. Course to be followed by minor plaintiff and applicant attaining majority. Now what? छोटू बन गया बड़े भैया. अब what will happen? A minor plaintiff or a minor to a party to the suit on whose behalf an application is pending shall, on attaining majority, elect whether he will proceed with the suit or election. First is election. Where he elects to proceed with the suit, he shall apply for an order discharging the next friend or leave to proceed in his own name and for leave. So he will discharge and he will provide for leave to proceed in his own name. The title of the suit or application shall in such case be corrected so as to read henceforth thus: A. be late a minor by C. D. his next friend but now having attained majority. Where he elects to abandon the suit, he shall, if a sole plaintiff or sole applicant, apply for on an order dismiss the suit on repayment of the cost incurred by the defendant or opposite party, which may have been paid by the next friend. May have been paid by the next friend. An application in the suit shall be made ex parte, but no order discharging a next friend or permitting a minor plaintiff to proceed in his own name shall be made without notice to the next friend. Where minor co-plaintiff attaining majority desires to repudiate suit. Now, when minor co-plaintiff attaining majority repudiate the suit, where minor co-plaintiff attaining majority desires to repudiate the suit, he shall apply to have his own name struck out as co-plaintiff, and court have found if it is not necessary the minor is not a necessary party, he shall dismiss him from the suit and such cost and otherwise things fit. Then notice of application shall be served on the next friend, co-plaintiff on the defendant. Application is necessary. Unreasonable or improper suit, where a minor attaining majority of a sole plaintiff apply that a suit is instituted by next friend be dismissed on the ground that it was unreasonable or improper. Notice of the application shall be served on all parties. Upon being satisfied of unreasonableness or impropriety, may grant the application. The next friend to pay the cost of the next friend will pay the cost, and anything done in the suit may such order thing. Rule 1 to 14 except rule 2 it apply to persons of unsound mind. So order 32 was related to the minority and unsound. So they have laid down the provisions for the minor, and under rule 15 they are saying whatever has been gone from rule 1 to 14 except 2A to apply to persons of unsound mind. Alright, and 16 is saving. So nothing contained in order shall apply to the rules of foreign state. He is suing or being sued in the name of or being sued by the direction of the central government, the name of the agent. Nothing which shall be considered by or derogating provisions of any local law. So they are saving the local laws against suing things. Just come back to rule 2A once, and what was special about 2A. 2A was security to be furnished by when so order. this is the indigent person. Security shall include the court fees payable to the government. So this will not be there on the suit of unsound mind, where rest all will be the same. So in the next session we'll continue from order 32A and order 33.